So I get this question a lot, and it is probably quite common, or there's probably a lot of people that just assume one answer to this question incorrectly. And I really would love to clarify this for everybody, because there's an assumed misunderstanding about this question that can save people a lot of trouble and a lot of heartache in the long run. So somebody asked me this question. They said, can you please tell me if a common law trust will protect me from foreclosure if my name is on the note? I assume they're asking about the promissory note with the mortgage. I currently have a non-revocable spendthrift trust, but now fear this doesn't protect me as is different from the common law trust. Can you explain the difference? I was told that the creation of a trust after a note was signed does not protect you from creditors. I was told that okay, first off, I was told if you have a trust or had a trust set up for you, why are you not reading books on trusts? Why are you just saying I was told? Don't rely on what somebody explains to you or tells you. Successful people in life don't rely on what even if it is an expert that set it up for you. Somebody told you something. Go to Amazon.com, go to Barnes & Noble, and type in trusts, and you will find a ton of books on trusts. You can also go to the free education section on my website, Understand Contract Law, and youwin.com. Put the mouse over free education. When the drop down comes, you move the mouse down and you click on the free documents section, and there are I think there's like a 60-something page free downloadable PDF on trusts. You can also just go to the search engine, startpage.com or google.com or bing.com, and you can type into your favorite search engine free ebooks about trusts. And there's a ton of them. You can one of the most famous ones is Weiss's Concise Trustee Handbook, WEISS', Weiss's Concise Trustee Handbook. And there's a very in-depth and very comprehensive one called The Art of Passing the Buck, Volumes 1 and Volumes 2. So, anyways, I was told that creation of a trust after a note was signed does not protect you from creditors. Creation of a trust after a note was signed does not protect you from creditors. Well, basically, does not protect. Well, I don't understand what you mean when you say does not protect you from creditors, because that's a general. There's no specifics there. Does not protect you from. What does that mean? You got to be specific with your. You could probably dissect that down into 8, 9, 10, 11, 12 different, precise, exact yes or no questions, and some of the answers might be yes, some of the answers might be no. So I kind of need more specific, precise, direct questions, but since it's a general blanket kind of this person doesn't understand what's going on or what this can do or can't do, I will take the time to try to help the best that I can, and the dozens, hundreds of other people that probably have the similar questions or similar mindset or similar level of comprehension about it. You know what? I will refer first and foremost back to the audio that I did about liens and what's the name of the audio? The different kinds of debts, secured, unsecured, and the ones that are secured debts that have liens. And let's see, there's one that I did called Understanding Debt and Secrets to Financial Freedom Revealed. Okay, so the part in there, the beginning part where I talk about understanding debt, I really go into detail. There's different kinds of debt. There's secured, there's unsecured. The secured debts have liens. Typically, the mortgage has a lien placed on your home, and so on and so forth. So really listen to that audio. Listen to it 2-3 times if you need to, and it really answers the question. It already answers the question, but just to spell it even clearer, or if something didn't get the way that I explained it in a certain way, specifically talking about trusts, you can sell the house to somebody else, another individual, man or woman, or a corporation, or a trust, or a church. You could sell the house to your spouse. If their name is not on it, you could sell it to them. Or if both their names are on it, you can sell it to them. They're the only person owning the house. You can sell it, transfer the title in any way to any one or ones, combination of entities, people, men or women, corporations, whatever. And it does not change the lien on the house. So if somebody comes by and says, I want to buy this house, by the time they cut a certified check, they are going to run a title search and find out, oh, there's a lien on the home, right? Now, if this is a trust that you set up or that you're involved with, when you are selling the house to yourself through a different vehicle, through the trust, although that's a misnomer, you're not really selling the house to yourself. I'm just trying to explain it in a way that you can understand. If Mrs. Smith sells the house to a trust that Mrs. Smith is a trustee or beneficiary of, normally, whoever is going to be buying that house, which is this trust, would do a title search to find out if there's any liens on it. And if there is a lien on it, they're not going to buy the house. They're not going to buy the house. Why would you buy the house with a lien on it from the old seller, and they're going to walk away from the house and not pay off the mortgage and satisfy the lien? Think about it. If you see a house down the street that you like, and you go there and you say, hey, I see a for sale sign, hey, and you assess the house and you get someone's opinion on it, and then you go there and you want to buy the house, you're going to do a title search, and you're going to see that, but at the time that you buy the house, there needs to be no lien on it. Okay, so otherwise you're not going to buy it. So you didn't do that because you sold the house to your own trust that you're trustee of, or that you're legal title holder in control of. So the lien's still there. You know it's still there because you already know, because you're the same brain involved with being Mrs. Smith and being Jane Smith, as trustee for so-and-so trust. Okay, so to answer your question directly, can any type of trust protect you from foreclosure, from a mortgage foreclosure? If the lien was placed on the house before the title was transferred, then no, it will not help you whatsoever. Okay? So let me explain that. If the lien was placed on the house before the title was transferred to the new owner, in this case the trust, then no, the lien is still there unless someone paid off and released the lien. Unless there's a satisfaction of mortgage filed and a release of lien filed at the county that the bank executed, and a title search shows that there's no lien, then the answer is no. So you might ask, well then what's the point of having a trust? What's the point of putting my house into a trust? Well, the point of putting your house into a trust, preferably before, well, actually, no, strike that. I don't want to go down that route. What I want to say is, to help, we'll talk about this instead. The benefit of putting your house in a trust is so that any other parties that you don't voluntarily contract with, like if you own a house free and clear and it's in Mr. and Mrs. Smith's name, or it's in so-and-so trust name, it don't matter. You could still voluntarily, the trustee of the trust can still voluntarily, or Mr. and Mrs. Smith, if it's just in your name individually, can just voluntarily go get a mortgage and then deposit $300,000. You're going to have to start making mortgage payments, but you pulled the equity out of your house. You got $300,000 or whatever the amount is, and now you're making, $1,200 monthly mortgage payments until the mortgage is paid off, but at least you got $300,000 out, right? So for, maybe you needed the money to bail someone out of jail for some really serious, your family member out of jail or something like that. Maybe you found an investment that you really want to take a risk. The risk that's there that you've assessed, you've calculated it, and man, if you could just get your hands on $200,000, you feel like it's almost a sure thing that you can make $1 million back from your investment. Well, if you own your house free and clear, get a mortgage, set aside that cushion of $100,000 and don't touch it, and continue to work and pay a mortgage now for $1,200 a month or whatever it is, and then you got $200,000 to gamble with your investment. Hopefully you'll make 2, 3, 4 times that back, but there's a chance you might lose it all in the investment, but hopefully you picked a good investment. So you want to be able to voluntarily take mortgages out as a trustee of the trust or in your own individual capacity if the house is still in your name. You want to have the freedom to do that. And that's fine. That's called a voluntary contract. You volunteered to allow the bank to place a lien on your house. What putting your house in a trust can do for you is, if someone that you are not contracting with comes and tries to put a lien on your house, like maybe the IRS. So that's one of the examples. Any party that you do not have a contract with, that you're not openly going and signing documents, yes, I agreed to get a mortgage, and yes, I agreed to let you put the lien on the house. You do that voluntarily. Because you want to. Because you want the money. But you gotta put up the house as collateral. That's a secured debt. Okay? But the benefit of putting your home in a trust away from you is to prevent, if Jane Smith or John Smith has liabilities, you haven't filed taxes in the last 5 years, or you have lawsuits pending, or you've created some sort of liability in your life, divorces, alimony, child support, whatever. Well, let's say that you're married but you plan on getting divorced, or you don't know where things are going to wind up and you might get divorced 5 years from now. You don't know. Which is everybody's scenario, because you can't predict the future. Right? So you don't know that your spouse is not going to sue you for every dollar that you have. So get the freaking house out of your freaking name beforehand. Then when you get hit with the divorce lawsuits or the lawsuits from the government or the taxing agencies or whatever, as long as the house was sold to that trust before you get hit with a lawsuit, before you get hit with a lien, which the judgment, so the lawsuit happens first, then the judgment if you lose the lawsuit, and the lien is placed right after the judgment. And then if they try to go and take your house, they can't, because you don't own the house. The trust owns the house. Now, what's one of the things that the taxing agencies do is they say, oh, well, we're going to reverse the transfer because your trust or your, what do people do? They set up these corporate souls or an LLC that you put the house into. The IRS attorneys are very good at getting the court to agree with them that the corporate soul or the LLC or the trust is just an alter ego of Mrs. Smith or Mr. and Mrs. Smith or Jane Doe or John Smith or whatever the individual's name is. They're going to have the court sign an order saying that those are just alter egos. Okay? And so look up alter egos and look up as many court cases as you can find, and I plan on collecting a whole bunch of them and putting them into the status correction course soon, showing you exact cases of where people messed up and how they're able to reverse the independence of that new owner of the home and say that it was just an alter ego. So alter ego, I mean, you just type into Google, cases, trusts collapsed, declared alter egos, examples, and try to find court cases. It might be hard to find, The Art of Passing the Buck is really, good at showing you ways that they would come and attack you in court and try to get it reversed. So you got to really know your stuff. You can't just put it into a trust and think you got to be the expert or know someone who is an expert who will be there for you to protect that, to prevent it from being declared an alter ego, and basically the fact that you put your house into a trust is null and void. It's like even if you did it 10 years ago, it's like it never happened if it's declared by a court order to be an alter ego of you. So you have to, how do you make sure that your trust is so independent and so legit, and that transaction is so, legit, and the documentation of that trust is so legit that it's not declared an alter ego and then nullified and reversed years later. Very, 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 very key. Otherwise, people selling trusts, if you don't know that, then people selling trusts is just nonsense. Or if you put your house into an LLC or a corporate soul, the same exact thing. Okay? Now, the other thing to look at, number one, the alter ego phrase. Alter ego. I'm just telling you, I've seen it over and over and over and over again in so many lawsuits, and people get screwed and they get their house taken away, and the IRS takes people's houses. Alter egos. Write that down. Do some research on that, and I will grab more research on it and share it with you. Okay? Now the second key phrase, exact key quotation mark phrase, control group. Control group. Or controlled group. Okay? If they declare that entity is a control or controlled group, it's another word that they use similar to alter ego. So, before you transfer your house or your property or your whatever into another entity, a corporation, corporate soul, trust, whatever, wouldn't it make sense to really hash out and find out where's the gray area, where is it black, and where is it white? What do I need to do to get this to never be reversed? Where is it black and white? And what's the gray area? Because the gray area, they can still come and attack you, even if fighting them for 2 years you might still win. Most lawsuits are battles of attrition, which means you're just wearing each other out. You're just arm wrestling, and you're both of equal strength, but whoever gives up first loses because you just don't want to fight anymore. So you want to avoid the gray area whenever possible, but if it's a gray area, you have a sliver of chance of winning. If you have a good argument in court, whether it's with you or you hire a lawyer or whatever. But make sure you don't fall into the alter ego or control group trap. And there's lots of lawsuits that you can find. Now here's the thing, is that it actually is very difficult to go on the court records and type in the words alter ego and control group and just have all the court cases that have ever been involved with this just pop up. They don't do that. They don't want us searching for court cases based on these phrases so that we can read 100 of them and find all the loopholes and find all the black and white areas and gray areas and learn what to do, because then we'd create little cliff notes for ourselves and we'd say, oh, make sure you do this and you don't do this and you don't do that. So let's try to work together. I'll try to put some stuff together for sure, and if anybody wants to contribute and put some stuff together, that's great. Contribute some lawsuits that you found, but it takes a lot of digging, dozens of hours of digging and reading, because if I'm going to share something with you, I got to read the case and see if it's something that's worth sharing, because I don't want to waste your time and just send garbage, and I want to condense and get the best of the best stuff, and then put outlines in the margins and write little cliff notes and sticky notes and post-it notes, and I want to do all that. I want to do all that work for you. So that's kind of why the status correction course is an indefinite endeavor. It's like never going to end. There's endless amount of research. There's endless amount of things to find and to share with people. So that's why it's a lifetime membership, because I assume the people that are involved with this, there's wealth of value in it already, but it is a lifetime membership so that they really get their bang for their buck for their involvement with that package. We plan on grabbing a lot of different court cases and outlining them, and then pointing little arrows and sticky notes in the columns and showing people, this is the reason why this person lost. Don't fall into this trap again, right? But it's really for people that want to maybe make a career and help people over time, or just really learn as much as they possibly can and just study, or just or people that are just, if you just know nothing and you just jump in and you just dissect all this information, maybe even if you don't even use most of it for the first few months, just by diving into a law study course and just listening and reading and watching the videos and the recorded conference calls, while looking at the documents and the cases and reviewing them and just reading them, it really brings people a long way along further upon their journey quicker. Okay? But with the status correction course, please just call us and find out if there's a particular process or goal that you have. Oh, I want to get rid of this credit card debt, or I want to become a secured party credit. Just call us and make sure that, because for some people it is a big investment and maybe they've been saving up to buy that package for a while. Just call us and ask us, hey, is this covered in the status correction course or not? Will I be able to learn how to eliminate my taxes or my student loan debt, or fix my credit report? Just ask, because I don't want to have it be assumed that, oh, this package is going to give you the remedy for everything that you ever need in terms of debt elimination and this and status and credit repair and putting your house in a trust and all. It's got a lot of stuff in it, but we can detail it and answer your questions as to what's in it and what's not in it. But ultimately what it is a law study course. Okay? It's a law study course, and it gives you all everything to become a secured party creditor, all the documents and instructions. However, it's much, 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 much quicker and easier and faster to do it correctly, to have us do the process with you. That's the SPC done with you. It used to be called the SPC done for you, but we're kind of changing the name to SPC done with you. Okay, we do it for you as far as making sure all the paperwork is 100% correct, but then you're the one, reading it, obviously, signing, notarize, and mailing and filing, so that you learn. We want to empower people. We want people to learn, unless you are blind or a paraplegic or in prison or something like that, and you can't really have access to a notary or to read. or to sign stuff, or you're really in a situation where you don't have access to printers or a vehicle or a mode of transportation to get to, I mean, now they have Uber and they have Lyft and they have all these different things so you can go or you can have a notary come to your house, but if you don't have a way to mail your documents and you're really just in a tough situation or you really have some bad health issues, okay, well, we have a situation where we can do the paperwork and mail the paperwork for you as your power of attorney. But I really like to dissuade that. I want people to learn. I want people that are healthy and have transportation to sign, notarize, and mail and file their documents themselves, because I want to empower people to through doing the actions. You learn so much rather than having somebody else do it for you. So the status correction course has a lot of empowering information in it, and we're basically combining the education from Empower Yourself Pack into the status correction course. So it's kind of like you getting the status correction course and the Empower Yourself Pack both in the status correction course. So it's kind of replaced the Empower Yourself Pack for the time being, and giving people study materials and specific cases and specific definitions and specific examples, showing people what doesn't work and pointing out and showing them, here's why this person's case got dismissed. Here's why this person did not win, challenging jurisdiction in the court because of this, this, and that. We point it out and we teach you. It's very empowering information. But again, if you want to first just get your SPC stuff filed, I would highly suggest you do the SPC done with you / done for you. If you want to save money and just do the status correction course, it does have the tools of how to prepare your documents. It's got examples that you can copy, and it's got step-by-step stuff in there. It's just you're gonna do it a lot slower, and you're gonna have to meticulously put all the details into it yourself. But we give you the tools to do it. It just takes a lot longer. So one of the things I'll leave you with, and we have step-by-step in the status course, or if you work with us directly and you have some assets that you're trying to protect, but one of the things I'll just leave off on this liens and transferring property into trusts. If you have 2 levels of separation, then it's like 10 times more powerful. You can almost never have a court reverse. In other words, instead of just transferring your house into a trust before the IRS comes and puts a possibly or an ex-spouse or whatever with a divorce decree, they come in and they put a lien on your house, or a credit card company suing you and getting a judgment and putting a lien on your house. But if you are planning on, okay, let me put my house in a proper trust or proper, corporate sole or whatever it is, before those things happen, like well before, even if you don't even expect them to happen, these things just come by surprise sometimes, as we're all learning the hard way, right? But if you're saying, well, I want asset protection, I don't want this house to be taken just, because there's liability in your own legal name, right? There's not liability in some trust or corporation that you just set up last weekend. There's no liability because you're not doing business, you're not doing commerce, you don't owe taxes yet, right? Or maybe at all. If you're not making any income, you don't owe any taxes. So that's the whole point of a trust is, you just set up a separate, it's almost like a separate dummy trust just for the purpose of putting your house in, that doesn't have any contracts, doesn't go into any commerce, doesn't have any income, so it doesn't owe any taxes. So no one's going to sue the trust. It created no liability. Its only purpose is to just sit there and do nothing and just hold the house. Does that make sense? So you, through your own legal name and you and your spouse's legal name, have created so much liability over your life. You've had different jobs, you've had different tax liabilities, you've had different, maybe you have child support, divorce, ex-wives, ex-husbands, maybe you've had lawsuits, maybe you've had car accidents, maybe you've You never, business partners, you don't know all this different stuff. It's in your own legal corporate fiction, all capital letters name. That's the liability. When you go and just set up another trust yesterday or today, there's nobody that even knows the name of the trust. There's no public registration of the trust, most likely. There's nobody has any claim against it. So that's the point of putting the house or whatever other property into the trust. Or the money that you have in the bank account, cut a check and send it to the trust. And have the trust have its own bank account. Okay? But what I'm going to give you, which is a huge, people learning the hard way, do 2 sales. Have the property, whatever it is, money, car, boat, plane, homes, commercial properties, whatever, anything in the world. Gold, jewelry, computers, anything. Whatever you're trying to protect. And it could be all of your stuff. It can be sent to a trust, or you can have multiple different trusts to hold different things. It just starts to get a little complicated, but if you're very advanced, you can, put 1/5 of the assets into this trust, and then this one into this trust, and then each home in a separate different trust, and you kind of like diversify everything. Another thing is you can put every single pet that you have and every single automobile that you have in a separate trust, because they create their own higher risk of liability. You can have a dog go and bite the neighbor, and if that dog is literally owned by its own trust and that's the only piece of property, the only thing they can do is put the dog to sleep. They can't go after your house, they can't go after your other pets, they can't go after your cars, right? And if you have every single car or method of transportation in its own trust, if you, God forbid, cause some crazy liability with one car, it doesn't have to be you. It could be, you let your son or daughter use the car and they go and there's some horrible there's some horrible accident. You run over a dog, you run over a human being, and they sue you. They can only sue the trust. If the car is registered in that trust, they can only sue that trust. So if every method of transportation is in a separate trust, then they can't take this one and they can't sue this trust and then take the other trust. Okay, unless it's a controlled group, and that's what you need to look up what the definition is. I'm not going to give it away. You're going to get the most learning from reading it, and just by knowing the definition isn't going to help you as much as really digging in and understanding what that means. So it cannot be a control group. But another nugget of gold: when you do your transfer into the trust or other entity, do 2 transfers. Now, you may not be a good idea to do them, seconds from each other. Okay, but sell your home to a third-party friend. Have that transaction be completely done, and then have that friend, wait a period of time, a few weeks or something, or months. The longer you wait, the better it looks. And have that friend then sell it into the trust. So now that home is 2 sales, 2 levels, 2 transfers separated. This way they can't they'd have a much harder time reversing and saying that, well, that trust that the home is in is just an alter ego of Mrs. Smith. You will say, well, wait a minute. Mrs. Smith sold the house to Mr. Jones. We're not family members. We are not blood relatives whatsoever. And that's a key. If you read these trust books, it's a key. It's called an adversarial party. A non-blood relative or if you were business partners with somebody, like president and vice president of a company that you guys started for the last 15 years, and then you went and set up a trust and you guys were both the 2 trustees on it, that would be called a control group, because you already have past involvements in it that give you guys a bias to help each other. Okay? That's what a control group is in a nutshell. So you have to find an adversarial party that you have no other business dealings, no other significant business dealings with, no blood related. Okay? So if you sell the home to a third party, I mean, obviously it's going to be a friend of yours. It's not going to be a non-friend. Obviously it's going to be a friend of yours, but it's going to be someone that you don't have any other business entanglements, histories, or if you do, they're completely closed and they were years ago and you haven't been involved with them and there's no outstanding issues or liabilities related to them. But you don't have any outstanding, any involvements with them, and they're not blood relatives. And you sell the home to them, and then they wait a while. You're still living in the home, but you just sell the home on paper to them. That's all that the sale is, right? And then they sell it to the trust. I guess you could say that you could go a step further. You could sell the home to the friend. You can leave the house, live in a hotel for a month, and then have them sell it to the trust, and you're the trustee of that new trust, and then you go back into the home. I mean, if you were able to document that you did all of that, there's absolutely no way in the entire world that they'd ever be able to reverse it years later or a day later. I mean, you truly transferred the title multiple times, and you even left the house or were evicted from the house for a while until, you know, your friend, by the grace of God, came and, you know, well, if there was, a contract needs to have consideration both ways. So again, for these transfers to be valid, there needs to be consideration exchanged both ways. Now here's the other thing. If you sell the house to your friend and there's only $10 exchanged, and then he sells it to a trust and, you know, there's only $10 exchanged, that's a gray area. If the value of the home is $300,000, there needs to be something that's about $300,000 exchanged for something that's about $300,000. That would look the best way to maintain the legitimacy of that sale. Okay? But there needs to be consideration, and it needs to be seen by a judge as that the reason why this transfer happened was because the consideration was about equivalent. You know, party A believed that they were getting, it was a both parties felt that they were getting something from the deal that they both were happy with. Not, hey, I need to get this out of my name so in case I get sued, you know, blah, 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 we're just doing this on paper, whatever. I mean, if you have someone that is forced to admit, you know, gets scared later down the line and admits that when they're subpoenaed in a deposition under oath and things like that, if that scenario happens, it could happen in a rare instance, but these cases have already been hashed out throughout history. And the gray areas like this, you already have a way of finding out what they are and how to protect yourself from them and doing things to the T by the book. And anyone that just listens to someone and puts their home in a trust and then sends me an email saying, I was told that blah, 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 I was told that the creation of a trust after the note was signed doesn't protect, it doesn't get rid of the lien on the house whatsoever. And it doesn't protect you from the creditor that put the lien on the house before the transfer, but it can protect you after the fact, for sure. And it's just a matter of if the, quote, creditor coming after you for the money, if their claim is large enough, will they try to put a lien on the house even though it's been transferred to a trust And will they try to say that it's your alter ego and that it really was an invalid transfer and the trust is nullified and void and it's just a bullshit trust? Will they try to do that? Now, if it's a credit card company suing you for just $5,000, then they're probably not going to do that, because all it would take for you to say is, have the trust respond and put an answer in to the court and say, hey, this is our property. Well, we didn't sign no credit card agreement. Mrs. Smith did. And then they'd have to really use their head and their research on penetrating trusts in order to get that overturned. But if it's a mortgage company, you're talking about six figures, or if it's a large tax debt, or if it's something significant, then they're going to try to get those trusts. They're going to try to penetrate what you've done, and you need to really have done your strong research on preparing and transferring, doing the transfer or two series of transfers correctly, and having your trust or the trusts that you set up be very properly done. So I hope I gave you some homework. And the homework is still even ongoing for me. I have to, as I go and dig up these cases, I'm reading them and putting them together. The homework never ends. Okay, I don't want to come off as some, that I know. It's a lifetime endeavor. We're all doing the homework on it, right? But these are some areas that if no one's ever shared with you, these are some areas that you need to dig into if you're interested in protecting assets and trusts. So hopefully I reach a lot of people, and I know that I am because people always write emails. If you have any questions as to clarity on any of these things, just write me back an email. I may not respond to every single short or long email that I get, but I definitely take into consideration all the things that might be left out or that are not, that you don't understand. But if this is truly a topic that you're very interested in, then please listen to it more than once before asking some questions, because sometimes you need to hear it a couple times. And I really want to do follow-ups, but ask or answer questions and explain concepts that were not explained already. Okay, so just listen to it a couple times, and then write back if there's still some things that you want me to cover. And then obviously, I invite you to join the status correction course, because we cover a lot more in-depth stuff in there. Hey, just a little follow-up on what I said about the trusts and transferring the home into one entity or your friend, or one trust, and then sending it to another entity or a second trust to get it 2 levels separated. And I kind of even exaggerated a little bit, and I said, well, if you're living in the home, you sell it to your friend, and then you give him possession of the home, and then you leave the home, and then you have him sell it back to a trust. I'm not saying you have to do that. I don't want to get all these emails from people that are experts at trust, because I have a lot of very knowledgeable people on my email list, and it's hard for me to try to talk to the very advanced people, and to try to talk to the novices and the people that are brand new. So please understand where I'm coming from. I'm trying to reach I'm trying to reach preschoolers and master's degree people at the same time. So please don't send me emails and say, Tyler, you don't know what you're talking about. No trust in history. Have you ever had to go through those lengths and do that? I'm not the authority on it. I'm just trying to stimulate your brain. I'm just trying to jumpstart your brain if you've never even considered ideas like that before. And hopefully my stimulating of those ideas and getting the juices flowing up and down your spine and into your brainstem, and some people don't have the juices flowing as well and as fast as other people that are very well researched about this or very experienced at this. Okay, and there's people on my list that have already set up trusts for lots of other people. But all I'm saying is get the juices flowing and start thinking about things. And certain people are less advanced than others, so please, I kindly request that the people that are advanced please don't give me any stupid criticisms about oh, you don't have to do that and this and that. That's what people leave it to people to discover those discoveries themselves. When people read the court cases of people winning and maintaining their trusts and people never even getting sued at all or challenged because it's been separated so much from them, right? Or people losing. I don't know if I covered everything. But people winning, people losing, and people winning without even having it be challenged. See, that's the thing. You could point court cases to me and say, well, no, this guy properly put it into a trust. There was only 1 degree of transfer, and he transferred it out of his name to him being a trustee and his kids being the beneficiary. This is the court case showing after this long a battle in the appeals court, he won and it maintained his trust, and the IRS was not able to say that it was an alter ego and blah, 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 blah. Yeah, but he did that after 3 years of court battle and spending $75,000 on legal fees. We're trying to avoid all that. We're trying to do it ideally where the asset never even gets seen as an alter ego or control group of the original party who may have liability, be it threat for litigation later. And there's totally a way to do that and have the assets be completely 2-3 levels separated down the line and off the radar and not even be in existence. Let me just give you an idea. If your name ain't on the electric bill, if your name, you ain't getting any mail at that address anymore, you could be a completely private and confidential, anonymous, nobody knows that you live there, it looks like someone else lives there, and you could still be a beneficiary or a trustee in possession of that home, cloaked through other entities or individuals. And ain't nobody going to go after the house if it looks like it's separate, or if it is legally and factually, as a matter of fact, been transferred multiple levels of separation, and it's owned by other entities that your name ain't even nowhere on any publicly recorded documents at the land records or anything like that. You could still be living in the home and paying all the bills, but through cloaks, C-L-O-A-K. And you can, if you plan this in your whole lifestyle years in advance, you can have these assets never even be noticed by any of the creditors that come to sue you. Is this getting the juices flowing in your brain for some people? That's how you want to think 5 years in advance. You want the most astute detective to be able to look into all your shit, and it look like you're as broke as whatever, right? Or it looked like you live somewhere else. Or, I mean, you might live there, but you're paying rent to a landlord that is a trustee of one trust that you're a beneficiary of that other trust. Or you're a grantor in a revocable trust for that other trust. I mean, you can have so many layers of it that you can really avoid these trusts ever coming into question. I mean, there won't be a lien to be placed on an asset that looks like you have nothing to do with it anymore. And, you know, do you have to go through these lengths to do things like this? Absolutely not. But if your name is still on it as a trustee, and the creditor and the debt is big enough, they're damn right going to have their attorneys at least try to attack it and get it to be declared your asset and avoid trust and the dissolved trust, and that it's just an alter ego of you, right? So you could be as creative as you want with your knowledge, and the more knowledgeable you are, you can do as many layers of cloaking as you want as possible. But please, just a lot of these trusts come under fire and get attacked or even collapsed and canceled, and I've seen enough of it. I get emails every single month, multiple people trying to protect their stuff through trust, and it don't work. So people need some real help on this issue, and hopefully I'm leading some people into the right direction. At least, I know I am, but technically, are we correct by just doing the simple approach? Yes, but it's America, and anybody can sue anybody, and anybody can accuse anybody of anything. And if you don't respond in 30 days with your answer and objection and this and that, and you don't see that whole court case out through the end, it don't matter who's correct, it don't matter who's telling the truth. It matters who showed up. Who showed up in the court case at the right time and who didn't show up. And it's all about showing up 15, 20, 25 times in a row over 2 years. If you don't show up once, you lose. Remember in school where there was exam day, in whatever subject? If you don't show up for the exam, you fail. Now, if you're nice to the teacher and he's a little lenient, and some teachers were pretty strict though. If the teacher's lenient, he said, "Oh, you can take the makeup exam." A lot of my teachers did not give me any makeup exams. If you did not show up to school that day, unless you called the day before, your parents called and said, "Oh, she's really got the flu, she's in bed with a fever, there's nothing we can do. I have a doctor's note, she's literally sick, the doctor's forbidding her from going to school." Okay, but if you don't have something like that, if you don't show up, you lose. That's the name of the game. It doesn't matter if you're correct, it doesn't matter if you're right. If you're accused of something and you don't show up, you can lose. I'm not saying you automatically lose from, you gotta look at what the scenario is, but you don't show up, you lose. There's a saying, in life and in business, in order to go up, you have to show up. But we all can't predict where we're going to be 2 years from now, 5 years from now, 15 years from now. If we're going to be, if we're going to get that legal notice in the mail, if when we're on vacation somewhere on the other side of the world, someone's going to forward it to us in time that we think, or, you can't predict this stuff. My goal is to maybe help some of you to design your affairs and operate your affairs preventatively in advance from seeing the mistakes of others. And I think I'm in a unique position, or anybody that does this line of work is really in a unique position to see what mistakes people make. I see people emailing me mistakes that they've made every single day. I can tell, "Oh, you did that mistake. Oh, you should have done it like that. You should have had this set up like that." And so I think I'm in a unique position to be super duper creative in order to come up with advanced remedies that people have never created and sold at all before. If you go to any website that's giving information away for free, or putting a course together, or selling their processes, or even lawyers that sell trusts, I really don't think that anybody is going even close to far enough as they should. And here's the reason why. Because obviously most of the stuff is done by attorneys. The attorneys that set up trusts, they want the trust to be exposed. They want the party, the creditor that's suing you years later, to try to attack the trust and say that it's just an alter ego of you. Why? So that you go back to the same fucking attorney who set the trust up for you, that you paid all this money for, overpriced, a lot more than I would ever charge. They want you to go back to that same attorney and say, "Oh, so and so creditor's trying to penetrate my trust and take the house." And they want you to hire the same lawyer, because who are you going to hire? The same lawyer that set the trust up for you. That's exactly what they want. It's the biggest scam in the entire world. Maybe I'm exaggerating. I'm very passionate because I think it's a scam. I think they're defrauding people by doing that. Wouldn't it be better someone that's actually genuinely interested in helping you to protect your assets, not to line their pocketbooks 5 and 10 years later when you go and have to rehire them again? Wouldn't it be really great to have someone that truly wants to protect or give you the tools to protect your own assets correctly from day one, in advance, proactively, the right way, where no one ever even notices and no one ever files a lien, opens a lawsuit against that property? That's called an in rem proceeding, when they do you actually sue an asset or a piece of property, not an individual or corporation. But wouldn't it be great for someone that actually cares and wants to do it correctly from the beginning, rather than what all these other people are doing? So anyways, I give you a lot of tools, I give you a lot of resources. For people that need the most advanced levels of stuff like that, I avail myself to one-on-one. I have coaching calls on the website. That's the first place to start. That's not the only place that ends up, but we could design and orchestrate whatever sort of arrangement that is necessary, that is agreeable. But for starters, if anyone is looking at this and is serious enough about it, I think I'm in a unique position to give a lot of creative ideas. But I've kind of given all the tools to lead people in the right direction that are still going down the journey of studying this and learning as much as they can about it initially. On this recording, I don't think I really held anything back. I actually went back and hit the record button again after I finished and walked away, because I was inspired by another idea and I wanted to clarify something. So anyways, I truly do care, and I would love to see people set these things up correctly and not get them reversed, which is so common. And it's really a sad thing. So anyways, I appreciate it. I really am pouring my heart out on this topic. It's sad, the emails that I get of the failures that happen, and hopefully we'll put some cliff notes and examples and things together sooner rather than later in the status correction course, and we'll throw some of those materials up there for free as well, just to show people what's possible. But I'm gonna have to put dozens of hours of time and study and digging to really grab all the things that are out there and compile them together. So it has to be part of the package. Because obviously I do this full time and I have to eat, so I do request donations in exchange. But it's going to be fantastic stuff that nobody else out there is putting together a package of materials and education together on this topic. But this is just one little topic as part of that status correction package that we talked about. So anyways, send me your emails and we'll keep putting more materials together. Okay, thanks guys, bye.